Denta Jones, and in today's session I want to tell you about a recent case that involved a culture of long working hours in a company. The employee concerned had a biking accident on the weekend, and as a result of the injuries that he suffered suffered from dizzy spells, fatigue, headaches, difficulty concentrating and those sorts of things. He had, prior to his accident, worked typically from 9 AM until 9 PM at night. After his accident, he went through a 6-month period of working 8 hours a day, which of course many of us would regard as a normal working day. Over the next 12 months or so, he worked from 8 AM in the morning until 7 PM at night, and he came under pressure within the organisation that he worked in, the culture that he worked in, to increase his working hours and to work as sort of long and hard and late as everybody else. And of course he was struggling to do so. He became concerned that if he didn't keep up, that he might be subject to redundancy, or that he might not receive the same bonus as other people were getting, etc. So he tried to speak about this to his managers, and he found that the attitude that came back to him, in a nutshell I suppose, could be summed up as, if you don't like it, you know where you can go. And ultimately he ended up resigning over the issue, bringing a constructive dismissal complaint and disability complaint. His disability complaint was an indirect discrimination argument, so arguing that the culture of long working hours was a provision, a criteria or a practice of the employer that he, as a disabled person suffering from the symptoms that he had, was going to suffer a disadvantage or detriment as a result of. The initial tribunal felt that the culture of long working hours couldn't be relied on as such a PCP under the indirect discrimination argument, but it was appealed to the Employment Appeal Tribunal, and they disagreed and said that yes, that culture of long working hours could amount to a provision, criterion or practice. The matter was sent back to the tribunal to re-examine everything in the light of that. I think the interesting thing about the case is that it does show that the cultural norms, the things that perhaps aren't written down anywhere but just become part of the way things are done around here, can very much form the basis of a complaint, and that employers do need to be really careful about making people work long hours. I'm dealing with another constructive dismissal complaint at the moment where that forms a real part of the argument. Just because somebody has opted out of the working time 48-hour working week doesn't mean that you've got carte blanche to sort of flog every hour and every second out of that individual, and organisations do need to be really careful about that, not least from a sort of well-being and stress perspective. If you do have any questions, please do not hesitate to contact me. My email is adenton@refreshinglawltd.co.uk.